It is 9:30 East African time, and you're all welcome to the AF Mpanga Webinar on Cross Border Insolvency Experience in East Africa. We want to thank you very much for honoring us with your time and joining us today. With me, I have today's presenters, Ms. Rachel Nirinjie from Uganda Registration Services Bureau, Mr. Munio Toithi, partner with PwC Kenya, and Mr. Rajiv Gujadu from Bowman's, Mauritius. They will be discussing with us the issues. My job is simple, which is to lay a background to the topic for discussion and to guide the discussions as we go along. I will ask Priscilla to roll the dice and run through my small presentation. In terms of the background, cross-border insolvency deals with the framework for coordinating between different jurisdictions when there is an insolvency. The purpose is to provide assistance in the administration and recognition of insolvency proceedings started in a foreign jurisdiction. As we all know, there is in place the ancestral model law, which has been adopted in some jurisdictions as a blueprint, some fully and others with modifications. However, if we are talking about an insolvency scenario, we would want to centralize and sort of focus this discussion around a lender's situation. And if we can go to the next slide. Okay, typically this is what we have in a lending scenario. We would have a holding company. For example, here we've used the holding company in Mauritius that has subsidiaries in Uganda, Kenya, and Tanzania. Next slide, please. Next slide. Okay, so in a typical lending scenario, you've got lenders, you've got obligors, a security trustee, and securities. We're looking at a scenario where all group companies, including the holding company, are obligors, meaning they're participating in the loans. And all group companies are giving out security to the security trustee in favor of the lenders. Primarily, this would comprise mortgages, debentures. In a typical scenario, the main lender, sorry, the holding company would give a corporate guarantee and would give a pledge over its shares in the subsidiaries. Next slide, please. What does a loan clause say? You would find in most, now we're using the LMA clause. The LMA clause would cover an insolvency occurring in any member of the group, meaning if there is an insolvency in or an event of insolvency in any member of the group, that would constitute an event of default In other words, anything that happens in a member of the group that relates to insolvency would constitute an event of default, entitling the lender to accelerate the loan or take other remedial action. Next slide, please. Out of this, there are a number of scenarios that can happen. The first is, if you look at scenario A there, we have borrowing at holdco, which has been cascaded down to subsidiaries, and then holdco in Mauritius becomes insolvent, and insolvency proceedings are commenced in Mauritius against holdco, thus affecting the subsidiaries. In scenario B, again, the borrowing is at holdco, but it's cascaded down to subsidiaries. But a member of the group, one of the subsidiaries, for example, in Uganda, becomes insolvent, and insolvency proceedings are commenced in Uganda. What happens to the other subsidiaries, and what happens to the holdco? In scenario C, again, we're looking at borrowing by a subsidiary or by subsidiaries, with holdco providing security in form of guarantees or share pledge. And then holdco becomes insolvent, and insolvency proceedings are commenced in Mauritius. In scenario D, borrowing is at country subsidiary level, and then a subsidiary becomes insolvent, and insolvency proceedings are commenced in the country of the subsidiary. And in scenario C, insolvency proceedings are commenced in Mauritius, triggering parallel insolvency proceedings in different jurisdictions where the subsidiaries are located. There are a number of questions that would arise out of those scenarios. And you can move to the next slide, please. And among those questions, some of which we seek to answer today, the questions that come out are the following. Where does the lender stand as a secured creditor? How about the scenario where the lender is unsecured? How do we marshal the assets and coordinate the winding up as a whole for the best interest of the creditors? Which court has jurisdiction over the insolvency company? Can a court decline jurisdiction? Whether the winding up in one jurisdiction can extend to foreign assets? Whether foreign creditors will be entitled to equal treatment with local creditors in a winding up? The extent to which foreign insolvency proceedings preclude proceedings in other jurisdictions by other creditors? The extent to which local courts will recognize foreign liquidation proceedings and foreign liquidators and administrations? And the extent to which local courts will be willing to give assistance to foreign parties or foreign courts in respect to assets held in the jurisdiction of the local court. And lastly, how should the assets be dealt with if there are concurrent insolvency proceedings in several jurisdictions? Those are all questions that will arise, and with me to discuss and try and throw some light on some of these questions are the panelists. As I've mentioned, we have Mr. Muniu Toiti from PwC Kenya. We have Rachel from URSB, and Rajiv to give us the flavor from Mauritius. I would like to start by inviting Rachel to put up her presentation and then tell us what the position is as far as Uganda is concerned. Rachel, we thank you very much for agreeing to come, and we invite you to put up your presentation, Rachel. Rachel, please.
Thank you, Mr. William. It's a pleasure to be here again. to be hosted by one of my mentors. I did my clerkship with your firm. So it's a pleasure to be here this morning. I will display my presentation. I hope we are able to see the presentation.
Yes, Rachel, we can see your presentation.
Yes. So I have been tasked to share about cross-border experiences, cross-border insolvency in Uganda, the laws and experiences from the past insolvencies that we've handled in Uganda. Please excuse me, I have a bit of a cold, but I hope it will not interfere with my presentation. So the insolvency practice in Uganda is regulated by the laws as displayed. We have the Uganda Registration Services Bureau Act, which establishes the institution itself, URSB. And then we have the Insolvency Act of Uganda of 2011, which establishes the Office of the Official Receiver, and definitely the Companies Act, the Insolvency Regulations, the Fees Regulations, the Practitioners Regulations that regulate the practice of the practitioners in Uganda, and the Insolvency Investigation and Prosecution Regulations, which empower the official receiver to be able to investigate and prosecute insolvency practitioners, and also to investigate any issues that arise out of insolvencies. First of all, as I noted, the Insolvency Act of 2011 established the Office of the Official Receiver. The Registrar General is also the official receiver, as stated under Section 198 of the Insolvency Act. And her mandate is to regulate insolvency practice and also to license insolvency practitioners who are allowed or mandated to practice and oversee insolvency processes in Uganda. Uganda has been blessed with opportunities, and we have had several entities from different countries, entities that have businesses in different countries come to transact in Uganda. There are so many opportunities in investment, in insurance, in manufacturing, and I listed just a few companies such as IC Alliance Club, KCB Bank, Diamond Trust Bank, among some of the parastatals, some of the companies that have established businesses in Uganda and in East Africa. So definitely with these cross-cutting companies and businesses across borders, there are issues that arise, and whenever most of these entities are exploring the option of investing in an entity, the insolvency regime of those countries is very, very important. Most of them want to be able to know, in the event that I want to exit this market, is there a possibility? Are the processes streamlined? Will I be protected? Will I be able to easily exit the market? Or how is the law, basically the predictability of handling cross-border issues as and when they arise? So the official receiver has been alive to this fact, and we have been spearheading corporate rescue mechanisms and supporting businesses to thrive in Uganda. And we also participate on the global level in the Ancitro Working Group 5 meetings, the Africa Roundtable, the International Association of Insolvency Regulators, where we're able to share experiences with different regulators and different practitioners on the global scene to be able to appreciate how they are handling insolvencies and how they are dealing with some of the cross-cutting issues that arise from cross-border insolvencies. Cross-border insolvency, I think Mr. William Kasozi has been elaborate in defining it, but really in a layman's language, it's In relation to insolvency, insolvency is the state of being in debt and being unable to settle the debt. However, cross-border definitely arises from a state of having businesses or assets in more than one jurisdiction. But the person also has to be unable to settle their liabilities. So first off, you're insolvent as an insolvent debtor, but then you have assets and creditors in more than one jurisdiction than where you are. So for Uganda, the first attempt at regulating insolvency was done in 1931 with the Bankruptcy Act, which provided for the different processes. And subsequently, these processes were carried forward in 2011, which attempted at that time to adopt the ancestral model law, but still maintain the provisions as existed previously under the Bankruptcy Act of 1931. So the ancestral model law provides, like Mr. William Kasozi has said, it basically assists states to be able to have a modernized system and a fair framework to be able to effectively handle insolvency matters across borders, while the regime that we carried forward from the Bankruptcy Act incorporated aspects of reciprocity. And there was sort of a clash because on one end, the ancestral model law was providing for recognition and cross-border equality, while on the other hand, our act still provided for reciprocity, which turned out to be an impediment in enforcing the issues or matters for cross-border in Uganda. So the Insolvency Act gives jurisdiction to the High Court in terms of hearing insolvency matters under Section 254 of the Insolvency Act. However, also for specifically cross-border issues, we also have Section 231, which provides for applications for recognition of foreign proceedings to be taken still to the High Court. So the jurisdiction is still in the High Court. However, I will note that because of these issues that existed within the law, we have very few cases in Uganda on cross-border insolvency. Most of the cases that we have had have, in the presence of this lacuna, have decided to proceed under different options. For example, the case of Christopher Sells versus Carol Sells and Attorney General. In this case, they decided to proceed under committee, the common law principle of committee, and in order to have their proceedings recognized and enforced in Uganda. But and then we have had also other people proceed under the Reciprocal Enforcement of Judgments Act. However, this act is restrictive, and you cannot be able to present just any matter before court. It even restricts insolvency matters. So that whole impasse that existed really limited on the case law and the experiences that we have had in Uganda for cross-border cases and cross-border matters that we've handled. We have one of the notable, I think, companies that has been in receivership is Pencon Services Limited, which had loan facilities across borders from different jurisdictions and different assets across borders. So for them, what they opted to do was to appoint joint receivers. The lenders decided to appoint joint receivers from all the jurisdictions in order to be able to recover the money that they had advanced to this company. And then other investors have opted to use bilateral investment treaties. These treaties are spell out, they are more like agreements where you spell out that in the event of, for example, an agreement or disagreement, this is where we'll be able to go for a remedy rather than rely on the existence of a cross-border insolvency law that did not exist at that time. So World Bank, of course, also has tried to sort of create an incentive for companies to be able to, for countries to be able to incorporate insolvency, cross-border insolvency regimes by recommending that some of these recommendations be adopted in their reforms before loans can be advanced to those countries as they apply for funding and loans from IMF and World Bank. So the official receiver has recognized the impasse that has existed and the lacuna that the law has created. And therefore, last year, in 2022, we succeeded in amending the Insolvency Act of 2011, and we did away with the requirement for reciprocity. So, and I should note that from 2011, when the law was amended, actually from 1930, from the 30s, when the Bankruptcy Act existed, that required us to have a reciprocity agreement. There has been none. We've not had any reciprocity agreement with any country in Uganda, which has been an impediment. So with the removal of this impediment, we are optimistic that we are going to have more insolvency proceedings, cross-border insolvency proceedings happening in our country. The cross-border rules were formulated, which will put in place the practicability of how it will be done. However, they are still awaiting the endorsement of the Chief Justice. The regulations are being revised to be able to accommodate this new amendment under the Insolvency Act. So we anticipate that the future for cross-border practice and cross-border insolvency in Uganda is going to be really, really good. I think that's it. Thank you for listening to me. Back to you, Mr. William.
Thank you, Rachel. Absolutely amazing presentation. I see now we have made progress in terms of removing the requirement for reciprocity. I must admit that I agree with you that it's been a difficult time and that in the few cases that at least I have been aware of, every jurisdiction has been doing its own. We've had the case of Uchumi, where insolvency proceedings were started in Kenya, and absolutely no insolvency proceedings were started for the subsidiary in Uganda. So the Kenya receiver or administrator opted to leave Uganda on its own. As a result, parallel proceedings were commenced by other creditors in Uganda, leading to a lot of confusion and pulling back and forth for the assets. But I think that the point to take away from this is that the law has now been amended and the reciprocal enforcement requirement has been removed, and therefore we should see more and better cooperation between the courts when there is a cross-border insolvency. Thank you, Rachel. And it is my pleasure to move ahead and invite Mr. Munio Toithi to give us a flavor of what's happening in Kenya. Munio, you're welcome.
Thank you very much, William. Please confirm that you can see and hear me.
Yes, we can see you, Munio.
Okay, I want to share my screen. Can you see my screen? Can you see my screen?
We can't see your screen as yet.
Okay, let me. Okay, hang on a second. You can see my screen now?
Yes, perfect.
Okay, thank you very much, and a very good morning to colleagues in Uganda and indeed other jurisdictions that have joined us this morning. As William indicated, Munio Toithi is my name, a partner at PwC in Kenya, but I practice in East Africa. I am a licensed insolvency practitioner. So my sister Rachel, who's just presented, I would consider her my regulator by extension, because I practice not just in Kenya, but across East Africa. And I've had opportunities to actually work in Uganda and other jurisdictions. But my mandate this morning is to present to you on cross-border insolvency regime in Kenya and relevant developments since the Insolvency Act came into force in 2015. I will also share a few experiences, some that we have been involved in as PwC, some that we have picked up in the public domain based on various decisions, because it's a matter of interest to us. So William opened and took us through the ancestral model law and the purpose and the spirit of the law. So I won't spend time doing that, because also Rachel has done that. What I'll just highlight is that in addition to Kenya, quite a number of countries in Africa have adopted the model law as indicated on this list. And so we are making progress in terms of various countries putting in place measures to ensure that cross-border insolvency matters are handled in a coordinated manner, which is a very important factor in safeguarding the interest of creditors and wider stakeholder groups. Rachel touched on some of the developments in Uganda, where you are seeing a lot of entities that have interests across borders investing in Uganda. And so this is quite a relevant topic when you reflect on some of the developments around the Africa Continental Free Trade area, and the impact that is bound to have on flow of investments into the East Africa region, the elimination of trade barriers, and the fact that we see a lot of organizations entering into partnerships or mergers and acquisitions. I had an opportunity to visit Uganda 2 weeks ago, met quite a number of clients in Uganda, and several were talking about what are the opportunities in Kenya, what are the opportunities in Tanzania. We want to expand beyond borders. So this topic becomes quite important, but there are quite a number of countries that have also yet to adopt the model law. And what we have seen in practice is that the approach varies from country to country. And we've had a situation whereby we've taken appointments of either administration or receivership, and having to register our interest in those other jurisdictions. And some of the measures that we've taken to take control of, say, subsidiaries in other countries where they don't have, they've not adopted the model law, is appointment change of the board, so that we can take control of those entities as we try to work it out, or appointment of a local practitioner to support us in various proceedings. So those are some of the things that we have done. So in terms of briefly the legal provisions around cross-border insolvency in Kenya, these are enshrined under Section 720 of the Insolvency Act of Kenya, and elaborated in the 5th schedule of the Act. And the objectives are set out in the 5th schedule are consistent with what the purpose of the model law is, and Rachel touched on this. They are very similar in terms of the provisions in the Kenyan Insolvency Act and the Uganda Insolvency Act. Promotion of cooperation between courts and other competent authorities in as far as cross-border insolvency matters are concerned. Certainty for the business community in as far as trade and investment is concerned. Fair, efficient administration of cross-border insolvency, and ensuring the interest of all stakeholders is taken into account. Maximization of realization of value for the benefit of stakeholders, a very important aspect. And of course, the spirit of the Insolvency Act of Uganda, just as the spirit of the Insolvency Act of Kenya, is to provide an opportunity for a second chance for troubled businesses. That is the rescue culture, as opposed to the culture that was mainly focused on realization for the benefit of secured creditors. I've also highlighted the model law provisions that have been adopted in our Act and the relevant section of the 5th schedule, side by side to the relevant sections of the ancestral model law. I don't want to spend too much time on that. Based on the brief I got from William, is what are the experiences that I can share from a Kenya perspective, so that we see how the courts are interpreting these provisions, and also how the matter is evolving, because it's still early days for us here in East Africa. And so we are expecting that as we move along, we will see more case law coming through and providing more clarity on what to expect when we have these types of situations. But what I have found working for us as practitioners is being very pragmatic and engaging with stakeholders in a proactive manner, because some of these matters are not straightforward, and it's only when you are clear on what the objectives are, what the intentions are, and what the anticipated process or outcome is, you get support of your counterparties in other jurisdictions and indeed the courts. So a few select case studies for reflection. The first one is the case study that my sister has touched on, that is the Spencon administration, which commenced in 2016. I was actually appointed as the administrator of Spencon, several entities here in Kenya, together with one of my partners, a company that was involved in civil engineering projects, infrastructure projects, roads, bridges, water and sanitation across East Africa. So had operations in Kenya, Tanzania, Rwanda, and Uganda. And the group holding company was based in Mauritius. So upon our appointment, and this was actually a voluntary administration that was initiated by the creditors of the company. From experience, this seldom happens, but what seemed to have inspired it is that there was an investor, a private equity firm, and as you know, private equity firm from the UK, with exposure on what it means when a company is trading while insolvent and the responsibility of directors, the consequences of trading while insolvent. They initiated this particular process in consultation with secured lenders in Kenya. So naturally, what we did as insolvency practitioners is to reflect on what does it mean in as far as the branches in other jurisdictions are concerned, and also the assets in those other jurisdictions. And in the meantime, the entity had entered into other loan agreements with other secured creditors outside Kenya, and Uganda is an example, where facilities have been extended to the Uganda branch for purposes of the projects in Uganda, and security obtained in relation to the assets of the company in Uganda. So what happened is that we first had to register our interest in Tanzania. Tanzania is yet to adopt the model law. As I've said, there are varying sort of processes that you have to employ. So we filed for our appointment at the business registration and licensing agency in Tanzania, and that was well received. But there is also a requirement there for foreign debt to be repatriated, in the registration of the foreign debt to be done, so that you are allowed to repatriate any funds post-realization, and having taken into account the liabilities of creditors in country. And we have another example of an entity, that's ARM. I don't have it as a case study here, but happy to share the experience if the time allows. Then in Rwanda, the requirement is to file with RDB and apply in court for recognition of foreign proceedings. This is what is currently in place because Rwanda adopted model law in 2021. But when we did this assignment, we had to formally notify the authorities in Rwanda after notarization of the application by the Rwanda High Commission. That process took time. I think now the process is better. But for Uganda, because Uganda had the Insolvency Act 2011, Uganda was in place, we needed to make an application in court for the recognition of the proceedings. But as I indicated, and I was actually represented by my friend William here. So William has been in the game for quite some time. So what had happened in Uganda is the creditors in Uganda, upon learning of the action the creditors in Kenya had taken, the secured creditors actually appointed 2 receivers in Uganda to basically safeguard their interests, and they opposed the application in court. And what we did, as I've said, pragmatism is very important in matters of this case, is actually rather than fight it out in court, because what we find is that the only people that benefit in such a situation would actually be lawyers, but the creditors actually suffer because already you are exposed. You are dealing with a distress situation where you are likely to realize 100% of what you are owed, and then you are fighting it out in court. So we came together as the practitioners in Kenya and the Uganda practitioners and said, what is the main objective of these proceedings? How do we actually resolve this? And we came up with a framework where we clarified the duties of the Uganda practitioners, that's the receivers, versus the administrator appointed in Kenya in connection with Uganda proceedings. And so went to court as a unified voice to say, we've actually come up with a framework, and the court was very supportive because we obtained guidance from the court, and we entered into a consent settlement, and that guided how we then worked together collaboratively with our Uganda counterparts to drive that particular insolvency. So that's the SPENCON experience. Then subsequent to that, 2 years later, another matter, this one, we were not appointed, but we were consulted on the side. But basically, Isolax, a company originating from Spain, with several subsidiaries, including an entity here in Kenya, involved in projects in the energy sector, went into insolvency, and insolvency proceedings were commenced in Spain. And so the insolvency practitioner made an application. This is now an application in court to test the Kenya Insolvency Act provisions around cross-border insolvency. And when the application was made in court, in this particular case, as you can see, Kenya has adopted the unsaturated model law, but Spain yet to adopt that. So the issues for the determination were whether this application should be favorably considered, and the data recognized as the foreign main proceeding by the Kenyan High Court. The outcome of that particular proceeding was that that application was favorably considered by the courts here in Kenya, and the insolvency proceedings in Spain recognized in Kenya. So that's basically the first test based on the research that I've done in as far as the Kenya Insolvency Act is concerned. The second one was this entity, CMC, originating from Italy, that was involved in various projects here in Kenya. Again, the entity went into financial trouble, and basically proceedings of voluntary administration process started in Italy, and the practitioner here made an application for these proceedings to be recognized in Kenya. And this was actually objected by various parties that included some local engineering firms that were subcontractors to this particular entity. There was also objection from some of the suppliers and an objection from one of the secured creditors here in Kenya in relation to lending that had been advanced in these proceedings. But after the court looked at this matter, the proceedings were actually recognized, but with some safeguards that the court actually granted in terms of ensuring that the relief granted in line with the model law provisions in our law should not prejudice the rights of the secured creditor. So the other one that the court granted was that no assets of the company would be transferred or encumbered without leave of court. And this is basically to safeguard the interests of the Kenyan creditors and to ensure that whatever actions are taken by the practitioner are not inconsistent with the spirit of the law. And of course, a requirement for regular updates and full access of relevant information of the proceedings of the voluntary administration process by the Italian practitioners to ensure that the creditors in Kenya participate as appropriate in those particular proceedings. And of course, the provisions of the law around if any creditor felt aggrieved, either about the process, the pace, or substance of the proceedings, there was still room to go back to court and raise an objection. So again, as you can see, the evolution of this particular, the application of the model law. In this case, there was a challenge, but the court, having considered the submissions by various parties, still recognized the proceedings. The last case that I would like to share is a company in the oil and gas sector, that is Zarara Oil and Gas, that was involved in some projects in this country, again encountered liquidity challenges. This is a Mauritius-based entity, and you can see Mauritius has adopted the model law just like Kenya. And similar to the other cases, there was an application for recognition of these proceedings here in Kenya. Like the CMC case that I've just shared, the creditors opposed this application on various grounds, and the creditors in this case included the Kenya Revenue Authority and other creditors. Various issues were raised by the creditors, including public policy issues and the exposure of the local creditors to risks that would not be taken into account by the Mauritius practitioner. And there were various issues for determination by the court, whether the foreign representative had capacity to administer or reorganize the company here by way of the liquidation proceedings, and whether the insolvency proceedings commenced in Mauritius were prima facie proof that a debtor was in financial distress, because there was some of the challenges that had been raised by the creditors here were around the procedural aspects around the recognition proceedings. Again, in this case, the court, having considered the submission of various creditors, went ahead to grant the order around recognizing the proceedings here in Kenya, and the relief that the model law provisions in our law provide. And of course, like in the CMC case, determined that in the event any of the creditors felt aggrieved by either the process, the pace, or any concerns, they still had an opportunity to go back to court and seek whatever relief they were seeking. There was an evolution of this case, because subsequent to this particular determination, the practitioner, having been recognized, actually went back to the High Court, and in this case filed an application for a Kenyan licensed IP to be appointed as liquidator to deal with the assets in Kenya. That was last year, and the matter was determined back end of last year. And the court made an interesting observation and ruling, because it was of the view that having recognized the practitioner in Mauritius, and in the spirit of the cooperation that the model law provides, unless there were sufficient grounds to suggest that that practitioner could not act in the best interest of the Kenyan creditors in realizing the Kenyan assets, and because the court was acting as the supervisor in those particular proceedings, the court determined that the practitioner from Mauritius could actually act as a liquidator, despite the fact that the Insolvency Act in Kenya is very clear that only a licensed insolvency practitioner in Kenya can act as either an administrator, a receiver, or a liquidator, and would need the license from the official receiver's office. So that was quite an interesting development, where the court is actually going further to say, once we recognize the practitioner can practice, they are an officer of this court, and so there is no reason why another practitioner needs to be appointed unless it can be demonstrated that there will be incremental value or benefit to secured and unsecured creditors. So those are some of the developments and experiences that we've had in Kenya so far. We expect that there will be more clarity as we move along. Of course, this particular ruling raises questions as to then does the law in Kenya need to be updated or amended to take to basically recognize this particular development or ruling. So those are matters I know for the legal practitioners, our regulator, and other parties to determine. So William, that's what I wanted to share for this morning, but we're happy to continue with the engagement as we move along with this discussion. Thank you very much.
Thank you, Munir. Quite enriching experiences, and also seeing that in Kenya, you have been very active in this area. What I note, obviously, is that, and also from the cases that we've done here, the few cases that we've been involved in here, there is always that underlying undertone of national interest and public policy, and looking at protection of local creditors by the courts. Courts are always looking out to see that they protect the local creditors. The local creditors' concerns of their inability to participate or supervise foreign processes, and there is also the general fear, which there is, that foreign representative may not act in the best interest of local creditors. This often brings about a bit of apprehension in the courts and reluctance to grant these orders. But then again, from the experiences that you have cited, there's been good success and good precedents set in your jurisdiction, which I hope that if such matters were to come before the Ugandan court, we would be able to cite as authorities to guide us and to guide our judges in terms of reaching the decisions. Quite an enlightening discussion. May I then move on to Rajiv to give us a taste from Mauritius and tell us how Mauritius has dealt with these issues.
Thank you very much, William, and thank you to my fellow panelists for enlightening presentations. What I propose to do is just to start with, share my screen. Just if you can give me a minute. If you can just confirm, please, that you can now see my slides.
Yes, you can see your screen, Rajiv. Thank
you very much. Very good morning to everyone from Uganda, Kenya, and the various other jurisdictions that may be attending. It's a pleasure for me to share on the laws of Mauritius and the experiences in terms of how cross-border insolvencies are dealt with here in Mauritius. I just hope that by the end of this presentation, you will have a clear picture as to how Mauritius deals with applications of this nature. So effectively, what I propose to do is consider the access to foreign representatives and creditors and to courts in Mauritius, recognition of a foreign proceeding and relief, cooperation with foreign courts and foreign representatives, and concurrent proceedings that Mauritius may have with foreign jurisdictions. As we move to the presentation itself, just some introductory remarks. I will concur with what Manu has just said earlier. As you would have noted, Mauritius has also entrenched the UNCITRAL model law on cross-border insolvency. It provides for effective mechanisms for dealing with cases of cross-border insolvency with a view to promote objectives in relation to cooperation between courts and other competent authorities of Mauritius and foreign states, and it basically also provides greater legal certainty for trade and investment, the fair and efficient administration of cross-border insolvencies that protects the interests of all creditors, protection and maximization of the value of the debtor's assets, and facilitating the rescue of financially troubled businesses. So effectively, the 9th schedule of our Insolvency Act, which was brought into force in 2009, governs applications in relation to cross-border insolvencies. The scope of its application is where assistance is sought in Mauritius by a foreign court or a foreign representative in connection with a foreign proceeding. Assistance is sought in foreign state in connection with a Mauritius insolvency proceeding, foreign proceeding and a Mauritius insolvency proceeding in respect of the same debtor are taking place concurrently. Creditors or other interested persons in a foreign state have an interest in requesting the commencement of or participation in a Mauritius insolvency proceeding. So effectively, under the Mauritian law, foreign insolvency practitioner, as foreign representative, is entitled to apply directly to the Supreme Court. So there is no other process per se. It is an application that may be made directly, and a foreign representative may mean a personal body, including one appointed to administer the reorganization or the liquidation of the debtor's assets or affairs. So effectively, a registered insolvency practitioner in this case. So what happens when an application by a foreign representative to commence Mauritius insolvency happens? So the foreign insolvency practitioner is entitled to apply to commence the proceeding if the conditions for commencing such proceedings are met in Mauritius. This would be achieved through compliance with the provisions of the 2nd schedule of the Insolvency Act here when submitting claims in local insolvency proceedings. So effectively, Mauritius insolvency proceedings would encompass liquidation, receivership, voluntary administration of a debtor, or the reorganization of the debtor's affairs. So effectively, there is a right of participation by that foreign representative in the Mauritian insolvency proceeding. So upon recognition by the Supreme Court here, the bankruptcy division of the Supreme Court, of a foreign proceeding, the foreign representative is entitled to participate in the Mauritius proceedings. And foreign proceedings can include any interim proceeding as well, pursuant to a law relating to insolvency in which the proceedings and the assets and affairs of the debtor are subject to control by a foreign court for the purpose of reorganization or liquidation of the entity. Just to get onto sort of access of foreign creditors, so lenders, for instance, to a Mauritius insolvency proceeding, foreign creditors have the same rights regarding the commencement of and participation in a Mauritius proceeding as creditors in Mauritius. They would be subjected, however, and this is important, to the laws of Mauritius in relation to ranking of claims. So the fourth schedule of the Insolvency Act provides for those rankings. So effectively, secured creditors would come in after certain of the claims in relation to costs of liquidators and government fees and employee sort of protections have been catered for and have been settled. So basically, whenever under Mauritius insolvency proceeding notification is to be given to creditors in Mauritius, such notification has to also go to the known creditors that are actually do not have addresses in Mauritius. So effectively, there is a process that protects foreign creditors in the event of commencement of a Mauritius insolvency proceeding. The Supreme Court may order that appropriate steps be taken with a view to notifying any creditor whose address is not known. So basically, what would the notification contain? Effectively, it has to include and indicate a reasonable time period for filing claims and specify the place for their filing. Sorry, I'm just going on to, so this is the one. And it would also need to indicate whether secured creditors need to file their secured claims and contain any other information required to be included in such a notification to creditors pursuant to the laws of Mauritius and the orders of the court. So just to move on to recognition itself and relief, which is extremely important in cases where, for instance, there's a need for interim relief and protection of assets. So an application for, so a foreign representative may apply to the Supreme Court for recognition, as I've said earlier, in which the foreign representative has been appointed. The application has to be accompanied by a certified copy of the decision commencing the foreign proceeding, and a certificate from the foreign court affirming that the existence of the foreign proceeding. But in the absence of any such evidence, any other evidence that would be acceptable to the court of the existence of that foreign proceeding. So there is quite some leeway that is provided to the court when considering an application of this nature. There are presumptions that are applicable in regard to recognition. So the court is entitled to presume that documents submitted in support of the application are authentic. And in the absence of proof to the contrary, the debtor's registered office or habitual residence in the case of an individual is presumed to be the center of the debtor's main interests. Just moving on now to the decision to recognize a foreign proceeding in Mauritius. This would be done if the provisions of the Act in terms of what constitutes a foreign proceeding is satisfied, that the foreign representative applying for recognition is effectively one that satisfies the requirements of the Act. The application must be accompanied by, as I said, the certified copy of the decision commencing the foreign proceeding, and certificate from the foreign court affirming the existence of that foreign proceeding. Just to pause here to say that when foreign proceedings are recognized, it is when it is taking place in the state where the debtor has the center of its main interests. And as a foreign non-main proceeding, if the debtor has an establishment in the foreign state, so establishment would constitute any place of operations where the debtor carries out non-transitory economic activity with human means and goods or services. The court tend to take applications of this nature with expediency, and decisions are rendered at the earliest possible time. As I mentioned earlier, in terms of interim relief, I think that would be a major factor in the consideration of when structuring and seeking to protect assets. So from the time of filing an application for recognition until the application is decided upon, the Supreme Court may, and this is not De facto, an application needs to be made by the foreign representative or the foreign insolvency practitioner, where relief is urgently needed to protect assets, to seek a stay of execution against the debtor's assets generally, entrusting the administration or realization of those assets located in Mauritius to foreign representatives, and grant reliefs such as staying the commencement or continuation of individual actions or proceedings concerning the assets, rights, obligations, or liabilities of the debtor, suspending the right to transfer assets or encumber those assets, providing for the examination of witnesses, taking of evidence, or entrusting the administration or realization of those assets located in Mauritius to that foreign representative. So effectively, the court will grant as wide, depending on the application and its cogency, will grant as wide orders as may be sought to protect assets as part of proceedings that are being carried out abroad. So effects of recognition of a foreign main proceeding, what are those? So effectively, upon recognition of what is a foreign main proceeding, commencement or continuation of actions are actually stayed. It does not affect the right, importantly, to commence actions or proceedings to the extent necessary to preserve a claim against the debtor. However, there's a level of control that is applied as a result of the recognition. So execution against debtors' assets are stayed, as I mentioned earlier, and the right to transfer is suspended. So recognition does not prevent the court on the application of any creditor from making an order subject to conditions imposed by the court, that the stay or suspension does not apply in respect of any particular action or proceeding. It does not further affect the right to request the commencement of a Mauritius insolvency proceeding, and we'll come to that in terms of concurrency of proceedings, or the right to file claims in such proceedings. Upon recognition, the court may, at the request of the applicant, being the foreign IP, entrust distribution of all or part of the assets of the debtor located in Mauritius to that insolvency practitioner, provided that the court is satisfied that the interests of the creditors in Mauritius are adequately protected. Moving on now to protection of creditors and other interested persons. In granting or denying relief or modifying or terminating relief, the court must be satisfied that the interests of the creditors, including the debtor, are adequately protected. So therefore, the court may subject relief granted to conditions it considers appropriate. It may, as I said earlier, modify or terminate relief as well. So moving on to sort of cooperation with foreign courts and foreign representatives. So effectively, the Act empowers the Supreme Court to cooperate to the maximum extent possible with foreign courts or foreign representatives, either directly or through an insolvency administrator, and is also entitled to communicate directly or request information or assistance directly from foreign courts and or foreign representatives. Likewise, insolvency practitioner may, in the exercise of its functions, cooperate to the maximum extent possible with foreign courts or foreign representatives. So communication directly with foreign courts is there's an empowerment to do so under our Insolvency Act. So in terms of cooperation, the forms that they may take, so cooperation may be implemented by any means, including appointment of a person at the direction of the court, communication of information by any means considered appropriate by the court, coordination of the administration and supervision of the debtor's assets, approval or implementation by courts of agreements concerning the coordination of proceedings. As I said earlier, the provisions has been made for concurrency of proceedings. So effectively, after recognition by the court of a foreign main proceeding, the Mauritius insolvency proceeding may be commenced only if the debtor has assets in Mauritius, So therefore, this element of where the debt assets of the debtor are located is of prime importance. The effects of that proceeding shall be restricted to the assets of the debtor that are located in Mauritius, and to the extent necessary to implement cooperation and coordination to other assets of the debtor that under the laws of Mauritius should be administered in that proceeding. In terms of coordination of a Mauritius insolvency with a foreign proceeding, so where the foreign proceeding and the Mauritius proceedings are taking place concurrently, the court will seek cooperation so that when the Mauritius proceedings are taking place at the time the application for recognition is filed, any relief granted must be consistent with the Mauritius proceeding. And if the foreign proceeding is recognized in Mauritius as a foreign main proceeding, the effects of recognition of the foreign main proceeding does not apply. Just to add that when the Mauritius insolvency proceeding commences after recognition or after filing so timing is key here, or after filing of the application for recognition of the foreign proceedings, any relief in effect will be reviewed by the court and may be modified or terminated if inconsistent with the local proceedings. If the foreign proceeding is a foreign main proceeding, the stay and suspension shall be modified or terminated if inconsistent with the local proceedings. Just to close on the aspect of who has received a part payment in respect of its claim in a proceeding pursuant to law relating to insolvency in a foreign state may not receive payment for the same claim in a Mauritius proceeding regarding
Yes. Hello, hi, Rajiv. Rajiv, can you hear me?
Yes, we can. Thanks.
So
Thanks, William.
we had a power blackout. Unfortunately, this thing happened. Yes. Please go on.
So I had reached the end of my presentation, William, by the time the issue arose.
Okay. Okay. Thank you, Rajiv, for this. I think the importance of Mauritius cannot be underestimated because we've got several entities that are domiciled in Mauritius, with parent in Mauritius. So it's important for participants to know about the situation in Mauritius and how do you get a foreign proceeding recognized in Mauritius, and what is the effect of the Mauritius proceeding in terms of other subsidiaries, and what happens in Mauritius if an insolvency proceeding was commenced in Mauritius. We've come to the close of the presentations. It is now an open Q&A section. So I would ask those who have questions to raise the questions. But before I do that, to thank the presenters for wonderful presentations. I would raise the caveat that the presentations do not in any way constitute legal advice, and one would be advised to seek proper legal advice in case they need it. The floor is now open to the participants to raise questions. You can either put up your hand or post in the chat room. Any participant with questions? Anyone out there with something burning that they would need to ask any of the panelists, or have the panelists been very clear and succinct and there is nothing to ask? So far, I see no hand. Maybe I can ask Rajiv, are you aware of any proceedings that have happened in Mauritius?
Unfortunately, William, we spoke about this whilst preparing for this presentation. We don't have sort of notifications or it's not in the public domain in terms of applications that are made. So it's very much between the parties. So and they are few and far between at this point. So effectively, we have a problem in terms of getting public information on those proceedings, access to those to those proceedings that may take place in Mauritius.
Okay, I see a hand there from Mwesi J. Mwesi J, can you speak up and raise your hand? And there is another hand from Emerald Gerald. So Mwesi J first and Gerald next.
Thank you, Mr. William Kasozi. The discussion has been very wonderful. I missed the introductory part of this meeting. I would like to understand what exactly is cross-border insolvency, because I found the meeting underway already, so I missed it. Thank you so much.
Okay, Chris, quickly speaking, cross-border insolvency is a scenario where there is an entity operating in several jurisdictions, and an event of insolvency occurs in one or more jurisdictions relating to that entity or its subsidiaries. That is cross-border insolvency. Gerard, can you raise your question?
Thank you so much for William for organizing this, and also to the presenters for giving us a very wonderful presentation. So I just wanted to understand. I think and this one goes to council from Mauritius, yeah. I think we have a number of entities in Uganda who have possibly holding entities that are in Mauritius. And from what I understand, I think Mauritius is one of the economic safe havens. And we, even getting information, I think it's some sort of spiral web where even when you're doing due diligence on an entity that has lineage or incorporation in Mauritius proves to be a very big challenge, and which hinders. And I speak this from the perspective of counsel for a lender who is probably looking to do due diligence. So even when it comes to the insolvency bit, because in the event that there was an insolvency, I'll just, and you had touched on it earlier, where you said that there has not been any live event. Possibly, if I understand it correctly, possibly there has not, it hasn't yet been tested. But from your perspective, right, in the event that this happens, is there like a standard, you know, that this is what you need to go through ABC, or this authority going to this authority? Is there like a standard process that even I seated in Uganda, even if I've instructed counsel in Mauritius, I can comfortably know that even if I've instructed counsel in Mauritius, at least I know the standard process that it's going to take, right?
Yes.
Is there such a thing?
Yes,
Yeah.
thank you,
Thanks.
Gerald, for your question. Effectively, the process that one would need to follow would be through a court process. So effectively, the Insolvency Act provides for how claims or applications are to be made to the court with regards to possibly a debtor that with whom an agreement has been entered into, or that their proceedings have been instituted in the foreign jurisdiction. So, and the manner in which any information will be obtained will be through effectively a court order detailing the information that would be required, and calling upon debtors to appear if need be on examination with regards to the application. So that is a possibility, but it has to go through a court process. It would not be possible to obtain the information in any other way. If that answers the question.
Just a follow-up, probably, Rajib. So
yes,
in the same vein,
yes,
would I be right to say that if I am doing due diligence, I probably might do it a bit faster with the court order, gotten through the process in Mauritius?
No, I mean, if it's a due diligence on an entity, let's say, which is licensed, for instance, here as global business companies. So effectively, that information can be obtained directly from the entities concerned. If there is no cooperation there in terms of obtaining the relevant information, then yes, that's the next option and only option in terms of obtaining information.
Okay, I think you've given it clearly, because I was faced with a scenario in my previous life where I had it was a complete nightmare. So I think you've given.
Okay.
You're welcome.
Okay, thank you, Gerard, and thank you, Rajiv, for that answer. I see a hand from Immaculate Akankunda. Immaculate, are you there? Immaculate Akankunda, you can speak now if you can hear me. Immaculate seems to have gone off. Anybody there? Any other question? You can post in the Q&A, or you can raise up your hand and you will be allowed unmuted to speak.
Yeah, William, not maybe just a comment to build on Rajiv's response to the question posed by Gerald. As and you rightly pointed it out, William, every situation is looked at on a case-by-case basis. I know there is probably not an example of recognition proceedings in Mauritius, but listening to Rajiv and myself and Rachel, the provisions are fairly similar, so maybe it's just a question of time. And the precedents that have been set in Kenya, in Uganda, may be reference points in subsequent applications in jurisdictions such as Mauritius, especially where there has been Mauritius main proceeding being recognized in Kenya. What we've tended to do in relation to Mauritius holdco is to leverage our network and the fact that we also have licensed insolvency practitioners in PwC Mauritius. So for example, in the Spencon case that I mentioned, we needed to sort of take control of the holdco at some point because of a very specific interest that we had in a particular asset that in our assessment as administrators had been irregularly transferred to several entities. Actually, it was a complex group structure, and we felt that we would have leverage pursuing that asset if we took control of the holdco, as opposed to without taking control of the holdco. But in determining whether to file for recognition proceedings or take control of a holding company, there are several considerations we have to make in terms of commercial considerations and the onerous nature of the responsibility of taking control of a holdco, because then it means you have responsibility over all the subsidiaries, and we always have to assess the benefit of doing that versus the cost and also compliance requirements. So it's very calculated case-by-case assessment to determine what is best for the interest of the company and the creditors. Thanks.
Yeah, thank you, Munir. If I may just add, I think the consideration and the balance that needs to be placed is also in terms of the assets of that holdco, which is generally is not held in Mauritius. And it is where the control element comes in as to how important it is to ensure that the subsidiaries are effectively controlled through the recognition in Mauritius.
Okay, there are a few questions in the chat room. One is to Rachel. Has Uganda incorporated the ancestral model law on insolvency? I will appreciate the citation of the relevant provision of the legal document. The other one is to Munir, I believe. What are the policy questions that might arise during CBIs involving other East African states? And again, another one from Munir. Does community law in East Africa provide a platform for harmonization of cross-border insolvency law in East Africa? If we can start with Rachel, has Uganda incorporated the ancestral model law on insolvency? And if so, what is the specific provision of the Insolvency Act or the regulations?
Thank you, William. As I stated in my presentation, Uganda actually adopted the ancestral model law in 2011. The only reason why it wasn't tested was because we had conflicting provisions. We had provisions that provided for reciprocity, and then we also adopted the ancestral model law, so it was hard to be able to test both laws at the same time. The provisions as of now, in light of the amendment last year that was done in the Insolvency Amendment Act number 20 of 2022, the provisions right now are from section 226 to 252 in the Insolvency Act of 2011. And then I will also add my voice to Mr. Munir's voice when he said that all these laws, for all jurisdictions that have adopted the ancestral model law, the laws are similar. The proceedings of recognition of the foreign proceedings are all similar. Most of them are adopted with a few modifications, but usually the processes are similar. Yes, I hope that answers your question.
Thank you, Rachel. Munir, what are the policy questions that might arise during CBIs involving other East African states?
Thank you, William. I am not sure I fully understand the question, but as we had discussed earlier in terms of the considerations in as far as cross-border insolvency is concerned, one is there is what are the jurisdictions involved and what are the legal provisions. We shared earlier countries that have already adopted the model law, and the provisions are very clear in terms of the objectives, the purpose of the law, and the procedural aspects. It's very important to understand that. And for jurisdictions that are yet to adopt the model law, it's very important to understand that what are you supposed to do? And like in the Spain court case, I indicated what we had to do in as far as Tanzania is concerned, which is filing an appointment at the business registration agency. In terms of Rwanda, then was notification to the Registrar General, and after notarization with the Rwandan High Commission in Nairobi, quite an onerous process, but we needed to do it so that we can have the proceedings legally recognized. And of course, other pragmatic aspects, like I indicated, the experience we had in Uganda. We filed an application in accordance with the legal provisions in Uganda. There was a challenge, and we then had to come up with a solution. We could have still gone ahead to debate the matter in Uganda and reach a decision, like the examples I gave in Kenya, but we felt it may not be good use of resources for us as practitioners to continue engaging in a dispute in court, but can we actually come up with our own solution? And the court actually supported us in that process. So those are some of the considerations I can say. But William, in case there are other aspects that you can think of in terms of this question, because I can see it's an East African perspective, please feel free to comment. Then the other question that was asked was around community law in East Africa, providing for harmonization of cross-border. Now, I must confess, I am not a lawyer. I'm not familiar with the community law in East Africa. But what I can say is the laws in Uganda, in Kenya, in Mauritius, in Rwanda have been influenced by the ancestral model law provisions, which provide for harmonization of cross-border insolvency and achievement of a fair adjudication of these complex matters. But I am not familiar that the community law in East Africa has provisions that will touch on cross-border insolvency. But my learned counsels on the panel are happy to support in addressing that particular question.
Thank you, Munir. My contribution to those 2 points is this. That in terms of policy, I think that most of the East African states, as Munir has stated, have taken the view that the ancestral model law is the blueprint which must be adopted, and most of them have adopted it. I think the differences in East Africa arise from the way the ancestral model law has been implemented in different states. In terms of the procedures, Munir has just described a procedure for Rwanda, which is completely different from Uganda, Kenya. Then also, if you talk about the East African community and harmonizing at the East African community level, I think that the harmonization really will probably not be happening in terms of a unified legislation at the East African community level, but at the point of a unified application of the legal principles across courts in the jurisdiction, because the principles are the same. If we can be able to develop a framework within which things that have been tested in one jurisdiction are able to be implemented across all jurisdictions, and the courts are able to consistently apply those principles according to the jurisdictions. I think it would be a much better approach rather than trying to find uniform legislation through the ESC. Any other contributions?
The only other addition, William, is actually from experience, which is a positive thing, is that even in jurisdictions where we've not had a model law adopted like Tanzania, we've actually followed the process that is applicable and we've been supported. So that's quite encouraging that the courts and regulators in the various East African states, when engaged appropriately, they make relevant considerations and they support realization or the process of insolvency proceedings across borders. Thank you.
Okay, we saw there was a hand from Gerard. Is it still valid, or you put down a hand? Okay. Do we have any other interactions, questions, comments? Gerard, you have something new?
Yes, William. I just wanted to ask. I know slightly of a couple of trades that are going on either between companies or financial institutions. I just want to ask, I think from the experience of probably the speakers, I know from Rajiv's perspective or from the Kenyan perspective, would the process still change when it comes to, because global markets trades are real time. So any minute that you take, I think, is either a gain or a loss to a party or another. From the perspective, I just wanted to just get a comment, I think, from the speakers, I think from the different jurisdictions, whether I think they have done it a slightly different way when it comes to global markets, in terms of either it is a trade, either a swap or a derivative that they have to close down because of an insolvency event.
Sorry, if I may take this very, thank you, William. I think there's a distinction to be made, and thank you for this question, Gerald, in terms of recognition and enforcement. So we are very much in the hands, so I'm not talking from a sort of local perspective here, but it's more general in nature. So even for a malicious insolvency practitioner looking to enforce, for instance, sort of on assets that are sort of shares or on the exchange in a foreign country, they would need to follow through the local processes and sort of comply with the relevant laws in terms of, for instance, in a share listed entity, for instance, they will have to ensure that they engage with the relevant sort of service providers within those jurisdictions before they can actually sort of look to secure assets. So these may be, depending on those jurisdictions, there may be lengthy processes, and as I've mentioned in my presentation, I think that's where the reliefs come in, and in terms of the intervention of the court. So it's important to, depending on where the enforcement is happening, to understand the terrain and take action accordingly.
I may also add that for most of the trades, there is a procedure for insulating them against insolvency proceedings. Most of them provide for a netting of arrangement immediately prior to the event of insolvency. So you might not be getting into strict insolvency issues because most of the trading agreements do provide for netting of or claims.
If I can also add my voice. Well, the purpose of insolvency processes and proceedings really is to preserve the value of the estate for an insolvent entity. And like Rajiv has said, the key thing that you need to do when you're doing these proceedings, and as provided for clearly under the ancestral model law, and even in our act, is to provide to seek for court's indulgence, get stays of execution in the event that you're worried that perhaps other creditors will come and attach their assets. There are those interim remedies that can be granted by court as you're proceeding to have your application considered by court for recognition of the foreign proceedings. So I don't think for multinational the international corporations, it's an issue of time. It's really more of preservation of the value of the estate for the benefit of most of the creditors. Yeah.
Okay. Anything else I see? Is there anything else written? What's that? Okay. That's it. We seem to have come to the end of the Q&A section. I thank everyone, the participants who have joined us for this. I hope there's been some useful information that has been obtained from this discussion. I also want to thank the panelists for having agreed to make the panel and for having agreed to join us today. Thank to you, and we thank you for your cooperation. With that, unless there is anyone with something else to add, I would want to bring this webinar to a close.
Thank you.
Thank you very much, William, and thanks to all participants. Bye-bye.
Thank you, everyone.
Thank you very much. Thank you.
Thank you for hosting us.
Thank you.
Pleasure.
Thank you, Rachel. Thank you, Munir. Thank you, Rajiv.
Thank you.
And thank you, all participants.